Hey guys, I hope everybody is doing well. We, in about 30 minutes, are going to be watching the ASAP Rocky trial, day 2. That's been pretty crazy. We're actually seeing the prosecutor kind of underscore how police investigations and the work that detectives do can be incomplete at times. So it's very interesting to see a prosecutor underscore that when it helps their case, because those are the investigations they're supposed to rely on to build a strong case before they expend the resources to take something to trial. But again, maybe that's why they offered a pretty sweet plea deal to ASAP Rocky. On the flip side, speaking of police investigations, thinking of Detective Al Hogan and his work in the investigation into the Jamari Holmes murder, for which Rodalius Ryan, and Damone Blalock were convicted of. Their appeal, unsuccessful. So the Georgia Supreme Court issued a decision today affirming the convictions for both Blalock and Ryan. The decision's the same across the board. Now, the beginning of the decision is going to restate a lot of the underlying facts of the case, but we're going to look at a summary of their arguments. All of the justices concurred to affirm these judgments from the trial. That means at this point, for Blalock and for Ryan, you know, I don't imagine an ineffective assistance of counsel issue going up to SCOTUS, right? So really what could change the game here for Blalock or Ryan would be the emergence of some type of evidence that was not available at the time of trial, right? They would file an extraordinary motion requesting a new trial or at least a hearing to look at that new evidence for the Supreme Court of Georgia to decide, hey, maybe this new evidence would change the outcome of the trial and consider offering a retrial. So as a quick summary of this, again, this came down today. And if this impacts you, if hearing this news hits you hard, if you get a jury summons, guys, try to sit on that jury. Try to do your part to take part in the criminal justice system. Talk to people when you hear, oh, it's crazy. Well, of course they're doing jail time. They must have done something to deserve it. That sentiment is very real. It's misguided, but with some conversation, people could change their stance on the accurateness, the integrity of the criminal justice system. So the little things that we can do if this bothers you, be proactive about it. So again, this is going to be all justices agreeing to affirm these convictions. So now, a lot of the arguments, we had 3 ineffective assistance of counsel arguments, plus a 4th argument that argued the cumulative impact of any or all of those 3 other prior instances of ineffective assistance of counsel. In the description of this video, if you want to go watch Brian Steele's oral arguments or read the appeal brief, they're linked in the description. But yeah, viewed in the light most favorable to the jury verdict, because the jury is the finder of fact. The jury knows more than the justices on the Georgia Supreme Court would know. The evidence presented at trial showed the following. On the day of the crimes, appellants Tahira Hartfield, that's Miss Brazy, and Mariah Smith were at Blalock's apartment. Let me zoom this in for you guys. Hartfield invited Bernard Mitchell, Rodney Uten, and Jamari Holmes, the victims, to meet up with her and Smith. When the victims arrived, Hartfield and Smith got into the victim's car, and Hartfield directed them to a nearby apartment complex where Ryan resided to buy marijuana. Upon arrival, Mitchell parked his vehicle, and the victims gave money to Hartfield, who exited the vehicle to purchase the marijuana. Hartfield returned a few minutes later and told Smith to come with her because somebody needed to see her. Smith got out of the car, and when she reached the apartment stairs, heard gunshots and saw appellants shooting at the victim's car. Neither Mitchell nor Uten saw the perpetrators clearly enough to identify them, but both told the police they saw a shooter who was tall with dreadlocks come out of the apartment breezeway with an assault rifle shooting at the car. Mitchell also told the police he saw another shooter at the corner of the building, though Mitchell did not recall seeing a second shooter at trial. Mitchell and Uten fled on foot after Mitchell's vehicle malfunctioned. Now remember, this was the stolen vehicle. Smith and Hartfield hid nearby until Ryan picked them up, and they returned to Blalock's apartment. When officers arrived at the crime scene, they found Holmes, who had been shot in the back of the head in the passenger seat of the victim's car, which had several bullet holes in the exterior. And I guess victims must mean the car that they were using for that night. Holmes was taken to the hospital and died shortly thereafter. Investigators determined that the fatal bullet was the cause of death. It was a .762. that they recovered fragments from Holmes' head. And then at the crime scene, officers recovered 7.62 shell casings and 9mm shell casings. Ballistics testing showed that all the 7.62mm casings were fired from the same gun, most likely a rifle, and all the 9mm were fired from the same gun, most likely a pistol. Investigators determined that, and again, this is like Hogan led this homicide investigation, Al Hogan, determined that the 9mm rounds were likely fired from the corner of the building close to the victim's vehicle, consistent with Mitchell's initial account of where the second shooter appeared. After fleeing, Mitchell and Uten called Hartfield and asked why they shoot at us. Hartfield replied, "They said the yacht was parked in front of the spot." Hartfield then texted Mitchell, claiming, "We did not set you up." Mitchell and Uten reported Smith's and Hartfield's potential involvement to police, and shortly thereafter located and interviewed the two women. Now, we heard a good deal, especially when it comes to Mariah Smith, about this interview and how she changed her story when she was fed some story and what she should be saying unless she wanted to get in trouble. We heard that testimony come out in the YSL trial. So, but the appeals court, they look at what they look at. They're not as well versed in the record as the trial courts. The interviews were video recorded and were admitted into evidence at trial. So we accept what they're saying here is those interview videos were recorded and admitted at trial. If the jury wanted to take a look at them at full, they could have done so, and we're going to rely on their fact-finding determination. Although Smith initially refused to admit that she saw appellant shooting at the victims and instead provided several alternative accounts of the crimes, she ultimately admitted to seeing appellant shoot at the victims. In contrast, the lead investigator testified that Hartfield was not cooperative during her interview and did not provide any information about what happened at the incident. After her interview with police, Hartfield messaged appellants on Instagram that she stayed solid and told police that she did not know what happened, but that Smith was snitching, so the police know about Blalock but not Ryan. Blalock replied that he knew Smith was a rat and asked what Smith had said about him. At trial, Mitchell, Uten, Smith, and Hartfield testified for the state. And then, we're going to skip some of this summary, but if you want to revisit the appeal brief, there's a transcript included of Hartfield's testimony, Miss Brazy's testimony. And if you want to see someone say, "I plead the fifth" 26,000 times, that's worth going back and reading. So you got to get that little bit of insight into the trial, this actual trial, not the YSL trial, but the actual trial for the homicide with what they included in that bit of an appeal brief. So check that out in the description. But they're going to go through the rest of this. Look, the trial, it happened. The jury determined what they determined. We're here to see if there's a strong appeal argument and if there was error, if it was harmful enough, if there should be a new trial. Appellant's theory of defense was that neither appellant was present during the crime, right? There was no justification. So we could be in a different scenario right now if at the trial, the argument was a different strategy. Yeah, we were shooting, but it was in defense. They shot at us, we were shooting back. That wasn't the strategy they took. They took an absolute innocence. We weren't even there. So strategically, that could have been a cause of an L here. Throughout the trial, appellants implied that Hartfield and Smith were shielding the real perpetrators. Blalock argued in his opening that the reason appellants were on trial was because Hartfield and Smith don't want to tell what really happened. To that end, appellants sought to persuade the jury that the state failed to present sufficient evidence to prove appellant's guilt beyond a reasonable doubt by highlighting Smith's shifting accounts of the crimes and Hartfield's invocation of her right against self-incrimination. For example, during closing, Ryan explained that the problem with Hartfield's invocation of her right against self-incrimination was that her silence didn't really help the jury figure out what happened. Both appellants contend that trial counsel rendered constitutionally ineffective assistance by A, failing to object and move to strike Hartfield's testimony after she invoked her right against self-incrimination in the jury's presence, and failing to object to the trial court's charge, so the jury instructions, on how the jury should assess Hartfield's invocation of that right. That text is all included in that brief. I thought it was a decent argument. And B, failing to review and introduce certain evidence that would support appellant's defense. And C, not objecting to each of the prosecutor's comments on appellant's silence during closing argument. Ryan separately argues that trial counsel was ineffective for failing to investigate his alibi. We address these arguments in turn. Now, with these, this is a good summary of what was argued in the appeal briefs, right? Now, the Supreme Court's going to go through what has to be met, what standards, what criteria needs to be met for this ineffective assistance of counsel claim to survive. They're ultimately going to decide that it doesn't. Appellants bear the burden of showing both that trial counsel's performance was proficiently deficient. So they've got to show that it was deficient and not just a matter of strategy. And two, on top of that, it's an and, that they were prejudiced as a result of that performance, right? So an actual harm to the outcome of the trial. That's citing Strickland v. Washington. This burden, though not impossible to carry, is a heavy one. So maybe citing this here suggesting Supreme Court saying maybe, but it's not that big of a deal. Maybe it was deficient, but oh well, so sad. To show deficient performance, appellants must demonstrate that counsel performed at trial in an objectively unreasonable way, considering all the circumstances and in light of the prevailing professional norms. So, our inquiry focuses on the objective reasonableness of counsel's performance, which we evaluate in conjunction with the attendant circumstances, and through the lens of counsel's perspective at the time. So again, if it seems like a good strategy at the time of trial, a strategy decision typically isn't going to be considered ineffective assistance of counsel. It was purposeful. We decided to do this because, from the facts that were available to us at the time, this strategy was the best defense. Not going to work on appeal. While also making every effort to eliminate the distorting effects of hindsight, right? So now looking back, you can't just go through it and say, looking back, we should have tried the other strategy, right? And then when we get over to the ASAP Rocky trial, and we know that the defense argument is it wasn't a real gun. It's not a affirmative self-defense justification. They were shooting at me and I shot a real gun back. It wasn't even a real gun. So can't be aggravated assault because we weren't really shooting at somebody. Or if anything, we were shooting blanks, and I don't know if that's completely harmless, but whatever, right? So in hindsight, if this strategy doesn't work, if this LA Superior Court jury that's sitting there for the ASAP Rocky trial doesn't buy into this theory about the starter gun, the gun's not really an actual firearm, it's a starter gun that we use in music videos, you can't just write to the appeals court and be like, oops, we want to redo because we want to try a different strategy, right? That can't be the argument. So, but yeah, thus deficiency cannot be demonstrated by merely arguing that there is another or even a better way for counsel to have performed, nor does counsel's subjective state of mind have any bearing on our analysis. The fact that defense counsel failed to articulate any strategic reasons for his failure made no difference because our inquiry is focused on the objective reasonableness of counsel's performance, not counsel's subjective state of mind. Rather, if a reasonable lawyer might have done what the actual lawyer did, whether for the same reasons given by the actual lawyer or different reasons entirely, the actual lawyer cannot be said to have performed in an objectively unreasonable way. To show prejudice, now this is the second criteria, right? To show prejudice, appellants must establish a reasonable probability that, in the absence of counsel's deficient performance, the result of the trial would have been different. It is not enough to show that the errors had some conceivable effect on the outcome of the proceeding. So, some effect whatsoever is not enough. And if an appellant is unable to satisfy one prong of the Strickland test, this court is not required to examine the other prong. So now we're going to go through each claims. So the first claim of ineffective assistance, appellants challenge trial counsel's performance with respect to counsel's handling of the following series of events. Before Hartfield testified at trial, her attorney indicated that Hartfield would invoke her right against self-incrimination pursuant to the Fifth Amendment of the Federal Constitution. Outside the jury's presence, the trial court discussed at length Hartfield's anticipated testimony with the parties and Hartfield's attorneys, as well as the types of questions which Hartfield could potentially respond without incriminating herself. The trial court emphasized several times, and the parties agreed, that Hartfield could not refuse to respond to questions that would not elicit incriminating responses. Well, she answered it to like random questions. It was kind of like the Woody I'm grown type questions, and she would say, I plead the fifth. So this didn't play out the way they planned it to. The state ultimately called Hartfield to testify. On both direct and cross-examination, Hartfield invoked her right against self-incrimination numerous times, understatement, though she also provided substantive responses to some questions. Appellants raised no objection during Hartfield's testimony to her invoking her right against self-incrimination. During closing arguments, counsel relied on Hartfield's silence. So again, they're saying, the appeals court is saying this was strategy. They didn't object, and it wasn't ineffective assistance of counsel. It's not like, oh, we were deficient, we should have known to object and we didn't. It was, we decided not to object because we're going to use her invocation against her as part of our closing arguments. So this is a strategy decision. There was a reasonableness behind this decision. So the counsel relied on Hartfield's silence to argue that the state failed to present sufficient evidence to prove appellant's guilt beyond a reasonable doubt. During deliberations, the jury submitted the following question to the trial court. How shall we interpret pleading the fifth? After both the state and defense counsel assisted in crafting a response, the court instructed the jury as follows. The Fifth Amendment to the United States Constitution guarantees that an individual cannot be compelled by the government to provide incriminating information about herself, the so-called right to remain silent. When an individual takes the fifth, she invokes that right and refuses to answer questions or provide information that might incriminate her about this case or any other. How this concept factors into your fact-finding and ultimate decision is for you to decide. Appellants did not object to this instruction. Appellants now argue that trial counsel performed efficiently by, 1, failing to object and move to strike Hartfield's testimony after she invoked in the jury's presence, and 2, failing to object to the trial court's response to the jury's questions. In support of these claims, appellants highlight the testimony of both the trial counsel at the motion for a new trial hearing, specifically, testimony that counsel had no strategic reason for not objecting to either Hartfield's invocation of the right against self-incrimination in the jury's presence, or the trial court's response to the jury's question. We are not persuaded. So here's why. We turned first to appellant's argument that trial counsel were deficient by failing to object and move to strike Hartfield's testimony after she invoked her right against self-incrimination in the jury's presence, pointing to decisions of this court and others that have recognized the potential for unfair prejudice that may arise from a witness's assertion of her right against self-incrimination and the adverse inferences that may follow. Appellants contend that their rights to due process and to confront the witnesses against them were violated by Hartfield's assertions of that right here. Neither side, and this is Davis v. State, neither side has the right to benefit from any inferences the jury may draw simply from the witness's assertion of the privilege, either alone or in conjunction with questions that have been put to him. So, they say, trial counsel were deficient for failing to object and moving to strike Hartfield's responses on that basis. But even assuming that an objection and motion to strike Hartfield's testimony would have succeeded, we conclude that it is not an objectively unreasonable strategy to forgo objecting and moving to strike Hartfield's testimony, since this strategic decision is one of several a reasonable counsel could have made. And again, this is why the Supreme Court earlier, like a few paragraphs ago, was saying they relied on it in their closing argument, right? So they clearly had some type of planning or consideration around these moving parts. It was a strategy, not ineffective assistance. The record shows it might have been a bad strategy, but it's not ineffective assistance of counsel. The record shows that, rather than objecting and moving to strike Hartfield's testimony, trial counsel opted to use Hartfield's testimony, or lack thereof, to bolster appellant's theory of defense. Specifically, during closing arguments, trial counsel emphasized Hartfield's refusal to respond to questions about her role in the crimes, as part of their defense that the state failed to present sufficient evidence to prove appellant's guilt beyond a reasonable doubt. Ryan pointed out that Hartfield declined to answer almost everything she was asked, and explained that the problem with Hartfield's invocations was that her silence didn't really help the jury figure out what happened. Both appellants referred to Hartfield's silence in an effort to cast doubt on the evidentiary value of the inculpatory Instagram messages. So we had those cited above. You know, I tried to stay quiet, but she's out there ratting, Mariah's ratting. But both appellants referred to Hartfield's silence in an effort to cast doubt on the evidentiary value of the inculpatory Instagram messages sent by Hartfield to appellants. So in other words, we've got to say that Miss Brazy was trying to cover up for other people by sending these messages in advance to like kind of sully the waters. Namely Hartfield's message to appellants that she stayed solid after her interview with police, by telling the officers that she did not know what happened, but that Smith was snitching to the police, so that police know about Blalock, but not Ryan. Ryan urged the jury that Hartfield's refusal to respond to questions about the Instagram messages was critical because the case is about what is proved, not about something that is suspicious, not about what might have been. It's about evidence. Ryan also suggested different reasons why Hartfield sent that message that did not implicate either appellant as a shooter, concluding that without the context of that message, the state had not proved its case. Blalock also emphasized the dearth of evidence presented by the state, arguing that the state's case hinged on Smith shifting account of the crimes and the inculpatory Instagram messages, an argument that was only strengthened by Hartfield's refusal to provide any substantive response regarding the crimes. Choosing to address Hartfield's testimony this way in closing arguments, rather than objecting and moving to strike Hartfield's testimony, was an objectively reasonable trial strategy and provides no basis for deficiency. So guys, what are you thinking at this point? Because where my mind is going, if the trial strategy is the only thing that made sense at the time, that's one thing. But if this was like the easy trial strategy, or we had an overburdened attorney that couldn't successfully do the work to argue a different strategy, then the question to me comes down to, what you can afford as far as representation at the trial level puts you at a fork in the road, right? And we've heard about the overload on the public defender system in Fulton County, Georgia. So it's not like, I will never tell you a public defender is not a good lawyer just because they're working as a public defender. Great attorneys help with court-appointed cases, right? Great attorneys take cases pro bono. So that's not what I'm saying. But even a good attorney, if they have limited time, limited resources, and have a million cases on their plate, especially, this is a homicide case, carrying a life sentence, it's a pretty big deal. How effective can your counsel be, your defense be? Can they really choose the best strategy, the one that they think would really work, if your resources are limited and you can only afford a public defender, and that public defender is extremely burdened with a bunch of cases, this Fulton County backlog? So, and that's not something that appeals courts will address or have any sympathy towards. They cite here Moon v. State that the making of objections falls within the realm of trial tactics and strategy, and thus usually provides no basis for reversal of a conviction. Moreover, a reasonable attorney also could have decided not to object and moved to strike Hartfield's testimony to avoid drawing the jury's attention to the questions and Hartfield's invocation of her right against self-incrimination in response. See Rashad v. State. And the Supreme Court saying, look, there's multiple strategies that could have been taken here, right? It would not be objectively unreasonable for trial counsel, as a matter of trial strategy, to refrain from objecting to this testimony so as not to draw attention to it. Finally, trial counsel were not deficient for failing to object and move to strike Hartfield's testimony because Hartfield gave several substantive answers that supported, at least by implication, appellate's defense. Hartfield denied knowing Ryan and denied setting up the victims or directing appellants to shoot the victims. Each of these denials could help to cast doubt on appellant's guilt. As such, it was not an objectively unreasonable strategy to forgo objecting and moving to strike Hartfield's testimony. That the jury apparently reached different conclusions about Hartfield's testimony does not mean that no reasonable attorney could have chosen this approach. Anderson v. State, the law is well settled that decisions relating to trial, strategy, and tactics are not to be judged by hindsight. So, next argument, deficiency because trial counsel failed to object to the trial court's response to the jury's question because they assert it improperly authorized the jury to draw inferences from Hartfield's invocation of her right against self-incrimination that were adverse to the appellants. But as we've already discussed, the record reflects that, during closing arguments, trial counsel sought to capitalize on Hartfield's invocation of her right against self-incrimination as part of their theory of defense, repeatedly pointing to Hartfield's silence as demonstrative of the state's failure to produce sufficient evidence to prove appellant's guilt. In light of that closing argument, it was not an objectively unreasonable strategy to forgo objecting to a jury instruction that permitted the jury to factor Hartfield's silence into its deliberations in hopes that the jury would view the lack of testimony from a key witness as to what happened on the night of the crimes as an indication that the state had not presented sufficient evidence to prove its case. The footnote says, because appellants raise no claim of trial court error with respect to the jury instruction. And we talked about this, right? This was all under ineffective assistance of counsel and not a judicial error for how the court ultimately charged the jury, gave them the jury instructions. So because appellants raise no claim of trial court error with respect to the jury instruction, we do not even address this issue. We do not address whether the trial court erred by instructing the jury as it did. Rather, we only conclude that trial counsel were not objectively unreasonable for failing to object for the reasons discussed herein. So they're not indicating whether this would have changed their decision if that argument was made on appeal. They're just saying they're not considering it. But still, it wasn't raised. Thus, under the circumstances of this case, we cannot say that trial counsel's decision to forego objecting to a jury instruction that could have benefited the defense was objectively unreasonable. Now, Barboza v. State, Georgia case says trial counsel's decision not deficient where failure to object to trial court's comments could be helpful to appellant's case. Also, Hampton v. State, trial counsel not deficient where failure to object to introduction of certain evidence may have helped defense. McKinney v. State, counsel's decision not to object to prosecutor's comments that may have helped support the defense, not objectively unreasonable. And guys, like the reason I'm like aware that appeals courts aren't going to reverse a strategy decision, reverse on a claim of ineffective assistance of counsel for what could be a strategy decision, is it's so well protected and established through the case law, right? I've seen it so many times that I've grown to understand it. Right? And here you go. Here we have the Georgia Supreme Court. Here's a case. Here's a case. Here's a case. Every case, all these cases, it's well established. Right? And that's kind of a scary prospect because your fate, if you ever go through the criminal justice system and get a jury trial or a bench trial, your fate could be in the hands of whatever strategy, trial strategy. And this trial strategy could get you here, whereas another trial strategy could get you here. And you can't go back after the fact and say, I want to redo because we argued the wrong thing. And that's really scary because sometimes trial strategy might not be arguing the thing that's actually really what happened. So, and when you go through other cases and when you're looking at the trial level, that's why I comment so much on trial strategy, because some strategies are really risky, but they pay off. Other strategies might be the safe route, and then they don't pay off. Like, think about that strategy with Doug harping on that watch. But then that juror said, well, was the watch Yak's? Was he staying at that house? Could he have been in constructive possession of the things he's being charged with that were found in Jeffrey Williams' home? Right? Like, think of the teetering scale. A little bit of butterfly effect. So... and I love this. Thank you so much to our, legal experts. We love Adventurin here in the chat. Adventurin says that's a good footnote. It means they can request a certificate of appealability on that basis at a later time. So that's awesome. Would love to see it. We'll stay tuned for that. And I imagine, do you know if that would get, if they were to file for that, would I be able to just go and look at the docket under the same number to look for updates, or would it come up as a new number? Because we can look for that. I would love to see that. Thank you so much for that. Everyone shout out Adventurin in the chat. That is great, great, great information. Give me 1 second. I want to let the ASAP Rocky stream know that we're still over here. And maybe I can change the start time to like 1 o'clock. We're going to redirect over there after we get through this brief. But, I saw this morning. I was stuck on a meeting and I was like, oh my God, this is big news. This is heavy news, but big news. Let's see. Change my scheduled start time. Let's do 1. And that's great because the California courts, they take longer lunches. So we can catch up while they're at lunch. And thank you. I see Jason over there, Jason Hodges, letting people know that we are doing this reading. So big appreciation to the mods holding it down over there and the mods holding it down over here. You guys are so awesome. And let's get back to this. So, in their next claim of ineffective assistance, appellants argue that trial counsel performed efficiently by failing to review and introduce into evidence Instagram messages provided by the state during discovery that, according to appellants, would have cast doubt on the state's theory of the case. Specifically, appellants point to Instagram messages sent by an unidentified user who asked Mitchell how he let Holmes get killed, to which Mitchell responded, "We didn't let him get killed. Hartfield and Smith set us up. We shot back." Mitchell reiterated in another message, "We were shooting back." And we heard Atkins really speak to the detective when he was questioning one of the detectives in the YSL trial. He was like, what does it mean if someone's shooting back? Well, somebody else was shooting first. When asked about these messages at the motion for a new trial hearing, Blalock's counsel did not recall seeing these messages during her review of the records, and Ryan's counsel testified that he was not aware of the messages before trial. Appellants argue that these messages undermine the state's ballistics evidence and testimony from the investigators that 2 shooters fired from outside the vehicle and that none of the victims returned fire. So the argument here would be, if detectives only recovered two shell casings and they determined that there were 2 shooters because of those, and those 2 shooters are both shooting at the car, well, how do you explain someone saying that they were shooting back? Because then there should be another firearm in play, right? Or there's only 2 total, and at least one of them is coming from the parties that say they were shooting back, right? So that was the argument there, as well as Mitchell's testimony that although he had a gun, it was unloaded, he did not fire at anyone, and he did not see anybody else fire from within the victim's vehicle. The trial court found that trial counsel were deficient in failing to find the Instagram messages, and the state does not dispute that finding. However, the trial court also found that appellants had failed to establish Strickland prejudice as a result of this deficiency. So, counsel was deficient, but they didn't argue why it was prejudicial. They missed the second criteria. We agree. Although Mitchell's message about shooting back may cast doubt on some of the state's evidence, we cannot say that introducing the evidence would have created a reasonable probability of a different outcome. Here, an acquittal. Levy state. First, given that Mitchell claimed to have fired back, the text messages in fact bolster evidence that shots were fired from outside the vehicle first. Second, the messages do nothing to undermine another strong evidence that the fatal shot came from outside the car. Investigators determined that the fatal shot entered the rear of the car, pierced the back seat, and exited through the front passenger seat where Holmes was sitting. Further, evidence showed that the fatal .762 bullet could not have been fired by a .22 cal gun, which was the caliber of weapon that Mitchell admitted was on his person at the time of shooting. Third, even if Mitchell's messages were presented to the jury, and we assume that the jury would have credited them, the messages do not definitively prove that there had only been one person shooting at the victims, as appellants claim. Appellants appear to reason that the ballistic evidence presented at trial showed there were only 2 guns used at the crime scene. Therefore, Mitchell's message would show that there was at least one victim shooting from the car, accounting for one of those guns, leaving only one shooter outside the vehicle firing the other gun at the victims. However, the state's ballistic expert testified that at least 2 different guns were fired, but explicitly clarified that he could not testify that only 2 guns were fired. Accordingly, appellants' arguments that Mitchell's message would have conclusively dispelled the state's theory is inaccurate. Given these circumstances, appellants have failed to establish a reasonable probability that the result of the trial would have been different had trial counsel reviewed and introduced into evidence the IG messages, and thus have not shown the requisite prejudice to support their claim of ineffective assistance. So, they cite here SteffJK v. State. No prejudice from counsel's failure to review a witness's prior contradictory statement because, among other reasons, such evidence was not exculpatory. And no prejudice where, even if counsel had not failed to carefully review the case files, the outcome of the trial would not have changed based on other evidence. And this kind of sucks because this is where we get to that heavy burden where, you know, the evidence that you guys failed to notice, failed to really incorporate because you said you didn't see it, there's a possibility that the jury could have concluded that that same evidence was actually inculpatory, bolstered the guilt of the defendants, rather than was it exculpatory. And if you ask me, this statement from the expert witness, where we can't really eliminate, we can't constrain it down to being only 2 guns, a jury, a reasonable jury, could find, that does impact us. Maybe we look at this situation a little bit differently. But just because they could conclude differently doesn't mean an appeals court's going to say reverse. So there's that. Appellants also argue that trial counsel were ineffective for not objecting to the prosecutor's comments during closing arguments, which they contend impermissibly commented on the invocation of the right to remain silent. Again, we disagree. During closing arguments, the prosecutor acknowledged that the defendants carry no burden, but urged the jury to listen for appellant's explanation in response to the following question. If the defendants were not committing the murders, where were they? And this was a big one, right? Because we know that for at least Rodalius Ryan, he apparently had an alibi, and his counsel didn't probe into it and introduce it at trial. So appellants object to the comment as burden shifting, but the trial court overruled the objection. And remember, this appeal did not argue judicial error, like error on the judge for a ruling that they made. They argued ineffective assistance of counsel. The prosecutor repeated the question, emphasizing that the defendants are both saying they weren't there. Tell us where you were. We didn't hear any evidence of it, obviously, but I would like to hear that answer. Blalock again objected to the statements as burden shifting. The trial court sustained this objection and instructed the jury. Tell us where they were should be disregarded. So we finally get an objection sustained and an instruction, a curative instruction. In his rebuttal closing, the prosecutor returned to the same theme. I wanted to hear the answer to that question. If they weren't committing the murders, where were they? The prosecutor continued and asked, at any point, did you hear an answer to the question? I did not, because they can't. They can't answer the question, because the answer is they were committing this murder. The prosecutor continued, the defense does not have to call a single witness or present a single piece of evidence in this case, but they can if they have it, but they didn't because they don't have it. And I hate this because it's burden shifting, but it's also implying that you should judge a defendant not testifying. A defendant's choice not to take the stand. And I get that practically, jurors are human, right? Jurors could judge. Oftentimes I think jurors want to hear from the defendant, the why. We want the closure, right? But at the same time, I don't love a prosecutor sitting here and making the argument that they must be guilty because they didn't take the stand. But trial counsel did not object to these comments. Pretermitting whether trial counsel were deficient by failing to object to each of the prosecutor's purportedly improper comments, appellants have failed to establish the requisite prejudice in light of the strong evidence of their guilt, including Smith's testimony identifying them as the shooters, the victim's testimony that corroborated Smith's account of the crimes, and that's a long footnote, we're going to get to it. Where was I? The victim's testimony that corroborated Smith's account of the crimes and the inculpatory messages sent between appellant and Hartfield. And they cite here no prejudice from counsel's failure to object to comments during state's closing argument where the state presented, quote, substantial evidence of the appellant's guilt. Also, Strother v. State, no prejudice where, even assuming counsel was deficient by failing to object during closing, other evidence of the appellant's guilt was very strong. So if this was the only piece of evidence, we might have come to a different conclusion. In addition, the prosecutor's statements were not evidence, and the trial court properly instructed the jury as much. This claim of ineffective assistance therefore fails. So let's read this really long footnote. Like, holy moly. And this was on the point that, pretermitting whether trial counsel were deficient by failing to object to each of the prosecutor's purportedly improper comments. In a number of cases, we have said, so this seems like they're going to cite Georgia Supreme Court decisions. We have said that a prosecutor may emphasize that a defendant has not successfully rebutted or explained the state's evidence. Okay, so this is case law allowing this. Don't love that. I don't love that. Kimbrough v. State, 2023. Viewed properly in the context, the prosecutor's comment merely emphasized to the jury that the defendant had not successfully rebutted or explained the state's evidence. I really don't love this. Ridley v. State, 2023, concluding it was not improper for the prosecutor to argue in closing that defendant had failed to rebut or explain evidence of his guilt and rejected assertion that such comments amount to improper burden shifting. I hate this. Johnson v. State, 1999. So we're going back a little here. Holding that state's make them explain argument did not impermissibly shift the burden of proof and did not comment on defendant's failure to testify. Ward v. State. These are all Georgia cases. I hate this for anyone on trial in Georgia. Oh boy. In this case, however, many of us have serious concerns that some of the prosecutor's comments, okay, they're saying this one may have crossed the line. In this case, however, many of us have serious concerns, but not serious enough, that some of the prosecutor's comments went beyond a permissible make them explain argument and instead amounted to a comment on appellant's failure to testify. That's exactly how I read it. And I'm still disappointed by this other case law in Georgia. That's rough. That's rough for any criminal defendant who doesn't want to take the stand. Prosecutors know that they can toe the line to use that against you. In this case, however, many of us have serious concerns that some of the prosecutor's comments went beyond a permissible make them explain argument and instead amounted to a comment on appellant's failure to testify. They're citing here Pine v. State 2024. A prosecutor may not comment on the failure of a defendant to testify, but he may argue that evidence showing guilt has not been rebutted or contradicted. Citation and punctuation omitted. Nevertheless, because we have determined that, and this is like a layering problem, right? Because if you have someone pleading the fifth with something that could give a substantive answer that would rebut something, well, how can we rebut it when this key witness is on the stand saying, I plead the fifth, I plead the fifth, I plead the fifth? You're not giving us the opportunity to rebut through a witness that could potentially have the information necessary, right? So there's layers and layers and layers here, right? A cumulative effect argument, but it's not getting there. A prosecutor may not comment on the failure of a defendant to testify. We read that, we were here. Nevertheless, because we have determined that the appellants have failed to meet their burden of showing that they were prejudiced by counsel's failure to object, we need not address whether prosecutor's comment was in fact improper. All right, so we don't need to determine that, we're suggesting it. This footnote's actually taking it there and suggesting it. We have serious concerns. But appellants didn't argue this. They didn't argue that they were prejudiced by counsel's failure to object, so we're not even going to get there. But yeah, so they're citing Bradley, the failure to demonstrate either. Is this one of the evidence books, or did they cite Bradley already somewhere else? Well, it says the failure to demonstrate either deficient performance or resulting prejudice is fatal to a claim of ineffective assistance of counsel and obviates the need to even consider the other. Because again, it's two prongs, it's two criteria there. So, yep. So, Adventurin says the important part to remember here is that an appellant court is viewing the evidence in the light most favorable to the state. And also, the assumption that whatever facts were presented, the jury, their decision, whatever decision the jury came to, factored that piece of evidence into their ultimate decision, right? And they're not going to reverse the fact finding unless it's like a matter of law or something so unreasonable. But that's why it's such a high burden to get there. I think we finished this paragraph, right? Because we went up to do that long footnote. So it's one of those things like, great, you had a footnote acknowledging that you had serious concerns, but practically it does nothing for Ryan and Blalock at this moment. Now they're addressing Rodalius' separate argument that trial counsel was deficient by failing to investigate and present his alibi to the jury. Specifically, Ryan argues counsel should have called his half-brother, who would have testified that he and Ryan were home playing video games at the time of the shooting. We disagree that trial counsel performed deficiently in this respect. Counsel has a duty to make reasonable investigations or to make a reasonable decision that makes particular investigations unnecessary. In any ineffectiveness case, a particular decision not to investigate must be directly assessed for reasonableness in all of the circumstances, applying a heavy measure of deference to counsel's judgment. So again, it's got to be like all the way up here. Moreover, a decision as to which defense witnesses to call, is a matter of counsel's trial strategy and tactics. So basically, Supreme Court saying, Mr. Ryan, the brother, he would have been the one to get this alibi in through, right? You got to put him on the stand if you want to get this alibi out in front of the jury. You got to have him testify. But if calling him to the stand would open up the door for other things that you don't want to be talked about, now there's a strategy, a decision to make, right? And if counsel at the time of court, they were in the state of mind, like, that's not great, let's not put him on the stand. I know he could give you an alibi, but we think this is a better strategy. Can't reverse that in hindsight. So moreover, a decision as to which defense witnesses to call is a matter of counsel's trial strategy and tactics and will not support a claim of ineffective assistance of counsel unless it is so unreasonable that no competent attorney would have made that decision under the circumstances. Smith v. State. Here, trial counsel testified at the motion for a new trial hearing that he was aware of the potential alibi defense, but elected not to pursue it any further. And this, you know what? On one hand, you want to appreciate candor to the court or whatever. But this is a moment where an attorney could have fallen on their sword. And how do we know that this is truly candid? Some people's egos are so big. This could be very true. Look, we genuinely weighed the options and we decided not to put him on here, and I'm being honest with the court. But there's also the possibility where this trial counsel has an ego, doesn't want to admit that, yeah, oops, I might have effed up big time by not putting an alibi witness on the stand. They don't want to fall on the sword. I can't say which one it is. But I can tell you, it would piss me off if it's the latter, if it's a situation where this defense attorney just has an ego and didn't want to fall on their sword. So, look, I don't get why. How could it be so bad? You have an alibi witness. And don't get me wrong, I just looked at a case where a man was exonerated after 3 decades. He had 18 alibi witnesses. So having an alibi, I get it. In an extreme circumstance, it really sucks. 18 alibi witnesses and receipts from purchases at stores where he was in a physical location out of county at the time the crime happened somewhere else. This man did 3 decades in prison. He was still convicted, right? That's crazy. That's crazy, crazy, crazy. So I get it. An alibi witness might not be the ultimate deal maker. But the example I gave is such an extreme. I can't reasonably... How bad could this potential witness have been for his brother if he were to take the stand? That it outweighed the benefit of getting an alibi out in front of the jury. And I don't know, maybe sitting at home playing video games isn't a strong alibi. You think like anyone can say that. But at the same time, I don't know if there's like records, like if it's on Xbox, you might be able to show you unlocked an achievement at that point in time. Was there any inquiry into this that could help corroborate? Yeah, he was playing the game with me and he got like Xbox bonus points because he downloaded a new skin at this time. Like there could have been other evidence here and maybe this trial counsel looked at it. I don't know. I can't imagine how we weighed this. So, but doesn't matter to the Georgia Supreme Court. They're writing it off as a reasonable strategy decision. Oh, am I off the screen? I'm like, do you just see my hand waving down here? I was going on a whole rant with my face blocked. It's probably for the better. I was over here having my moment back here behind Adventuran's comment. Oh my goodness. Yeah, I mean, I would love to hear it. I would love to hear it. And then to volunteer to the court. I'm not encouraging a lack of candor to the court, but technically, you could choose to fall on your sword if you believe in your client's innocence, even if your reason for getting there might be a little less than candid. Just saying. Just saying. And I would say in the interest of justice, if you really think your client's innocent, falling on your sword a little bit, I don't know. Just me. Oh, man. And again, it could all... The attorney you have could make or break your future, your fate. So, but yeah, counsel testified he didn't think the alibi defense would be persuasive unless Ryan also testified and also noted that evidence at trial contradicted the purported alibi. All right, so there was apparently a contradiction. Counsel instead thought it would be better to argue that there was only one shooter and that the other shots came back from the alleged victims. As a result, counsel elected not to investigate the alibi defense any further. I mean, this could mean conflicted by the evidence just because somebody said that Ryan was somewhere. So did this counsel just say like, well, Brazy's gonna say that Ryan was over, he had the weed, the marijuana, they were gonna buy marijuana. Is that the evidence that would contradict the alibi? Because that's not very strong evidence. So given the conflicting evidence and counsel's objectively reasonable concern, yeah, about the strength of an alibi, we cannot say that counsel's strategic decision not to investigate and present Ryan's alibi defense was unreasonable. C. Smith claimed that counsel was ineffective for failing to investigate and present alibi witness, failed where a witness placed defendant at the crime scene, and counsel believed that an alibi presented by defendant's girlfriend would not be persuasive. Accordingly, this claim fails. Finally, we consider whether the combined prejudicial effects of the cumulative effect of all this argued ineffective assistance of counsel. All of these assumed deficiencies. It was argued in the appeal brief, this warrants a new trial. When you look at the impact combined, if you don't think it's prejudicial on its own, together, hello. And they cite here Schofield v. Halsey, which was later overruled on other grounds, State v. Lane. In our review of appellant's claims, we assume that counsel were deficient for failing to review and introduce into evidence Mitchell's 2 Instagram messages and failing to object to each of the prosecutor's comments on silence in closing argument, as discussed in those divisions 2B and C. Counsel's assumed failures are unlikely to have affected the outcome of the trial, and we do not see that the prejudice from these 2 deficiencies would accumulate in any way to cast doubt on the verdict. It doesn't undermine our confidence in the jury's decision. Given the relatively minor impact of counsel's assumed errors, the appellant has not shown that the cumulative prejudice from those assumed errors likely affected the outcome of his trial. This claim, therefore, fails. So they're concluding here that the prejudice wouldn't have cast doubt, but they did also say that the prejudice wasn't argued. So this is a bit unclear. Are they making this determination based on what was argued? And would this have been different if the prejudice was argued? Because they did take issue more than once in their decision above with the appeal briefs not even addressing how it would have prejudiced the outcome of the case. All justices concur, judgments affirm. That means the convictions stand. The convictions stay. So there we go, you guys. Wait, are you lying? Is this true, Chloe? Chloe says Google, ineffective assistance of counsel, Google result. Oh, and this is like one of those jokes, like next to, in the dictionary, this person's picture would be next to it. Oh, this is hilarious. Chloe Albert's Revenge says if you Google ineffective assistance of counsel, the result should be see probation revocation hearing of Antonio Sledge. It's going to forever piss me off that attorney Derek Wright said, can I sit down? And just didn't even physically stand up for his client. This is going back to this argument of not wanting to fall on the sword. Even if you were actually ineffective. Like, if me saying, hello, I was wrong about something, or oops, I didn't do that, could save someone from having to do time, especially a life sentence, because I messed up, judge, yell at me. I couldn't live with myself if I didn't say, like, oh my God, I didn't even investigate that. And I get that it's hard to admit that you're wrong, but like, oh my God, sometimes you have to, like, have a spine. Like, you've... So here we are. I went into this like, all right, we're just going to look at the summary, but we read through the whole thing. Sorry, my pissed off rant was behind. I'm behind the wall again. Let me move my face. Let me get back up here. Where's my regular view? There we go. Hey, Chloe. Hey, Chloe. But this is great, Chloe Albert's Revenge. And speaking of, if you guys didn't get the memo, you know, Tiffany Adams, the Fit Lawyer ATL, and Jim R., Happily Angry Lawyer, they are going to represent Mungtung. So Tiffany Adams filed substitution of counsel, and then on Friday, Jim filed his admission for pro hoc vice status admission, because he's barred in California. So because Tiffany is licensed in Georgia, he's applying for that pro hoc vice admission through her, so that way he can also help represent Antonio Sledge. He mentioned possibly some motion on that maybe nothing significant, but some motion, maybe sometime this week. So we'll look at that. Also, Ashley Linnell had asked, is Diamante Kendrick out? I don't know. I mean, maybe something's happened since, but for Diamante Kendrick, the next thing I know on the docket is February 7th at 9:30 in the morning for his probation revocation hearing. So I don't know if there's been some type of resolution ahead of time that I'm not aware of where he could have gotten out. I don't see anything indicating that on the dockets for his outstanding cases. But as far as Diamante Kendrick, since that's kind of like adjacent to this, I think February 7th is the next date of interest there on an update there. Also, so good to see STS in the chat out here turning someone green. Big thank you to STS and hey to Simon. Gonna wave down here. I think I'm reversed. Am I petting Simon? Give him a good pat, a good boy pat. I think it might be on this side for you guys. It reverses my camera when it comes through on YouTube. But so good to see you. Thank you so much for the gift. And Coley has been here for 5 months, been green for 5 months. Love to see it. Big thank you. If you guys are in the chat, Factual Lie, thank you so much. Jess dropped the Fit Lawyer ATL's YouTube channel. Great content already. She did some interviews with different family members of YSL trial defendants. Really good stuff over there. All around great person. Really insightful, easy to talk to. So if you don't know who she is, this is the time to go check her out. And eventually maybe Jim, Happily Angry Lawyer, will get a YouTube channel. So, all right. So Relly is testifying today. Guys, we have a motion hearing with ASAP Rocky about an hour, and then we're getting back into testimony. We're going to redirect over there, right? So when I end the stream, it should take you over automatically. If you want to click the link to come on down, I'm just going to call ASAP. You can get on over there by clicking this link if you want to make sure you get carried over there if you think YouTube's going to leave you behind. No slime left behind. And we're going to look at this. Guys, if you have not tuned into the ASAP Rocky trial, we looked at day 1 yesterday. There's some crazy stuff going on. And the prosecution tried to turn over ballistics evidence at the last minute to kind of underscore defense theory that they didn't expect about the firearm that Rocky was carrying on the night was really a starter gun and not an actual firearm. So we've got prosecution trying to underscore that police don't do complete investigations. We've got the defense with a sergeant on the stand, Thomas Rizzo. We've got the defense counsel like, you searched everything, right? You did a great job. No stone left unturned, right? Like the defense is loving the officer testimony and the prosecution's hating the officer testimony, which is just really interesting to see play out. So lots of stuff going on over there. If you want to check that out, come over with us. And Peter Ortiz in the chat, also a 5-month member, says, I have missed my OG cat and fellow slimes. Heck yeah, missed you too. There was no hat yesterday. There was no hat cat yesterday on the day 1 ASAP Rocky stream. Just saying. So guys, I hope if you exit on out from here, have a great rest of your day. I'll keep you posted. We'll go live on the 7th to look at, we've got hearings for Courtney Clenny and Diamante Kendrick on February 7th. So if you're interested in that YSL update, see you then. If you're coming over, let's reroute. See you guys in a few seconds. Bye guys.